Today, I'm with Lance Johnson, a man who bridges the gap between complex engineering and high-stakes IP law. From his days as a patent examiner to pioneering a legal niche for Amazon sellers, Lance has seen the legal industry from every possible angle. We're going to discuss why he believes you should let your associates fail to learn and to keep them, how technology is the best leverage for a young attorney, and the reality of running high-impact practice in 2026. Lance, welcome to the Growth Switch.
Thank you, Alex.
Lance, could you tell us about how your experience as the patent examiner set you on the career path that you're on today?
Being a patent examiner was a unique insight into the inside of the patent examination system. And as a new attorney and a new associate, having that sort of insight was important, both to be efficient and to learn how best to utilize the contacts and information I had to get patent applications allowed for my clients so that they would have issued patents. That, in addition, became a helpful perspective when I started getting involved with litigation over defending those patents and prosecuting them, because questions often came up about how the patent got issued in the first place. And having had a personal experience inside the patent office, I had a pretty good feel for how that likely occurred, where to look for potential prior art, trying to find issues that might give my client an advantage, things of that sort. So it was really a fundamental start in my practice as a patent lawyer, which is then subsequently broadened out to far greater and larger things.
When you're thinking about your colleagues throughout your career and currently, what do you do in terms of looking for the same level of dimension, just not only knowing the law, but also having experience, whether it's them working in a patent office or having other experiences that give them that additional layer of exposure to better able to understand the legal matters and to better serve their clients?
Well, it's an interesting thing about being a lawyer in the United States is while the background training is general, because all lawyers have to be trained in exactly the same thing. There's no special examination for only patent lawyers that they only ever do patent law. I find myself in many instances in a case that it has a variety of issues. And I remember facing cases where the facts, as they start to come to light in terms of what my client is looking for or how it's presenting, a fact will pop up that here there's a third party contract standing issue. And there's a potential tort claim that isn't really a patent claim, it's something different. And it's the ability to spot those related issues that I find helpful. My training as a chemical engineer kind of gave me a system level approach to law and facts. So I use that kind of on a day-to-day basis to help understand both the facts in the case in front of me and to identify the legal issues of relevance for my client to give us the best chance.
Do you think that because it is easier to access surface level information now because of the tools available, whether it's the internet or AI, more attorneys because of that don't go in depth as they should be when they're doing their research, and sort of more old school approach when you actually needed to have that background or you had to seek out an expert that does, were serving the attorneys and the clients better?
Certainly the ability to find more information faster has exponentially grown since I was a young attorney. I think in general that's a good thing. In large measure, it depends on which side of the desk you're on. If you're enforcing a patent, having an opponent with access to a worldwide body of information on a keystroke is rather daunting, because there is a high potential for prior art or information that wasn't originally considered the first time. So you have that risk. If you are you are defending against somebody else's allegations, that of course is the flip side. It's very helpful to have that information. But I think what it does mean is that you build in additional steps. For example, if you're going to file a lawsuit, take an hour to do a preliminary search like your opponent would do to see if there's something easily found out there that's going to cause a problem. And if so, you find it, you address it, and you decide before you file suit whether this is going to be an issue. I am a strong advocate of advanced planning and defensive investigations of your own assets before you file suit and walk into court. Because once you're in the court, you're on the public record, consequences can happen, and the other side has a fair shot at exposing your weaknesses. It's better you know that in advance before you get there.
Absolutely. Would you maybe have any story to share where that extra step to take that extra hour to do the research before anything, is reported and out there made the difference regarding something that maybe your colleagues missed at the time and you taking the extra step made the difference?
I can think of two occasions. The first is that we'd gotten a patent for a client, and it was on a manufacturing process to make a product widely used. They had been using it for several years. And down the line, they found that there was somebody else who was making the same product. So they asked me to go ahead and file suit because they wanted to stop them. So I did my initial investigation and asked the client some hard questions. And it turns out we found out that the client had been using and selling the invention, unbeknownst to us, more than a year before the application was filed. In the United States, that's a no-no. That's an absolute bar to patentability, and it would likely mean that ultimately that information would come out during discovery, and the opponent would find that, and your patent would be destroyed. So we had a strategic choice to make. You want to file suit and hope to maybe the other side won't find it, which is a low likelihood? Or would you prefer just to stay quiet, keep your patent, but don't enforce it? Let others, if they find it, they see it's out there, maybe they choose not to compete, maybe not. Strategically, you have that choice to make because you can make it now. If we do it after you file suit, you may not have that choice. So that's one story. Gave the client an option they didn't have. The second one, we were on the defense in this case. We were being sued by a fairly large. My client was being sued by a fairly large company for a patent that it looks like they probably infringed. And same company had filed suit against another company, another competitor in the market. And so the cases were proceeding rather in parallel, the two defendants against the one plaintiff. They were about 2-3 months ahead of us. So we could see some of the procedural issues that the other side was going to use. And we knew we needed to do something somewhat different. And so my senior partner turned to me and he said, find something. That's a rather broad directive. Turns out this case, the inventor had been part of a nonprofit research organization that had been working off a government grant. And they had worked off of this for many years, a decade or so, trying to come up with this type of product to no success. And one day he tried something different and it worked. It worked really well. And it's curious, when I was going through the logbooks, the day after that experiment, the results came back, he did no work. A week and a half later, he and two of the executives from the researcher organization quit. They started their own company. He set up his lab. 2 weeks later, Viola, he developed a new invention that was just amazing. Sold it to the company for a fairly large sum of money. That became the basis for the patent that was being asserted against us. What they didn't realize, however, is that when he was working at the research organization, they were working under a government research grant. The terms of that government research grant required that they disclose all inventions to the government, and that because the magic language of the contract, they had assigned all of their rights to any inventions they might discover to the government. And so we argued that because this invention was actually discovered during the research term, by all rights under the contract, the rights should belong to the government. And so this plaintiff, the company in this case that had spent a huge amount of money for the invention, did not in fact really own the invention. The government did. And so we asked the government for a license during the lawsuit. Well, we lost at the district court on that issue, but we went up to appeal, and we happened to get an appellate judge who used to be a bench chemist. And so he was well aware of how to keep a logbook and what needed to be disclosed and sometimes what others didn't disclose. So he reversed on appeal and awarded standing to the government as the true owner of the patent. So our lawsuit was over. There was no infringement issue. We approached the government and my client got a license and there was peace in our time once again.
Mhm.
Now, that issue of standing in the government research grant had not been pursued by the other company. I was a very young associate at the time. And I asked my senior partner, when gave him the information, he said, "Are you sure this is right?" I said, "Yep, it's right." I said, "You realize the other side looked at this and they didn't pursue this." I said, "I don't know what they looked at and what they didn't, but this is what the information is. This is what it tells me." So he let me proceed with this, and we put it in our brief, and we pressed it forward, and it turned out to be the winning issue. So yeah, taking the extra step, the little larger perspective, pursuing a claim that others might miss. Sometimes that's the difference between winning and losing.
Fascinating. When you went on from that younger attorney to having more experience and managing your colleagues, how did you maintain that culture of letting the associates, find their own angle and try new things, even though, of course, there is a risk that might not be a winning strategy like it was in this case?
I always remembered as a young associate how important it was for my senior partner to give me the opportunity to fail. Because the adrenaline is never pumping quite so hard as when your own name and reputation is on the line and you have to stand up to the scrutiny of a senior partner who's going to quiz you and say, "Is this right? You sure? Because my name's going to be on this too. I don't want to sign something that's not right." And so you need to make sure you're right. That process in me instilled a strong sense of both opportunity and hope that what I would be able to do that for someone else when I got in a position to do that. And in fact, I did later. I was uh, lead counsel in charge of a lawsuit, and we had, I think, 14 attorneys on it, of various partners to young associates. And there was one associate he had been tasked with developing witnesses um, who were in the company at the time, who knew background information. And a lot of my partners, they would assign this sort of work to young associates to help them learn how to do that. But generally, the associates would gather the information and give it to the senior partner. The senior partner would then pursue it in the deposition, and it would make its way into the case. Well, we had a lot going on. And when I had them up that this guy had to be deposed, as well as three others in a similar situation, I turned to the associates who did the work and said, "You guys are going to have to get ready to travel." And they looked at me like, "Why?" And he said, "Because you're taking the deposition." I go, "We've never taken a deposition." I said, "Exactly. You are going to take the deposition. You have the greatest connection with these people. You know them. They like you. They want to tell you the information. I'm not going to throw that away. Go take the deposition." They said, "But are you sure?" And I said, "Yeah." Now, one of my other partners said, "It might be helpful to send a senior associate with them who's actually done it before." And I said, "Okay, that's fine." So I attached each of them to a senior associate who had actually taken a deposition before. And they went and they took the depositions. They took great depositions. One guy came back. He was so excited. He said, "You can't believe what this guy told me." I said, "What? What did he say?" He said, "He told me that he got a call from the opposing side, the company, after his paper came out, asking him if he would come work for them and take this information and develop it at their place." He said, I said, "What did you say?" And he said, "No, that's, he wanted to know what was going on. I had signed a confidentiality agreement. That would be industrial theft, trade secret. And so it wasn't going to do that." Wow. Now, this added a new dimension to the case. We settled 2 weeks later. So I'm a strong believer in both young opportunity for new associates. And if you have a witness who wants to tell you information, let them. You don't know what you're going to find.
That's a great story. And I think it also illustrates the depth of emotional intelligence required in cases like this, realizing that there are connections in the relationship being built, not just, how the law is applied. But with the growing complexity, especially when you have big cases with a lot of moving parts, what are some of the things that, as you gained more experience, you stopped doing so that you're not adding more, but something that you decided to consciously subtract from your process?
I think the greatest change in my practice has been the advent of electronic discovery tools. I mean, back in the day when I was a young associate, discovery was a process of going to a hotel room in the middle of nowhere, stacked with 75,000 documents in banker's boxes all around a conference room, and then spending 4 days going through all of those one at a time. That was pretty typical of a young associate when I was there. Uh, these days, documents are produced electronically. They're fed into an automated processing system and scanned for keywords that can then assemble and collate and combine and draw connections that were they would have taken a long time doing it manually if you were still paying attention long enough to be able to do that. I find myself now relying more on those who know how to run e-discovery systems to take the documents in and process them and find out what's relevant so that we can start building our case off that information. So I'm doing a lot less document review, but and leveraging the technology more. And in that regard, much of my practice is a solo practice, so I leverage technology all the time, and that's the only way I can play ball with the big guys who have a deep bench.
When we spoke before the podcast, you mentioned that legal industry is very resistant to change when it comes to adopting the new technologies. From your experience, could you give me one example when adoption of technology was maybe a bad call and more of a distraction than it was helpful? And in addition to the example you just provided, are there any good successful cases of where technology was adopted and it improved the life and the results for everybody?
Let me answer the last one first, because I was growing up as a lawyer during the time when computers were becoming a thing. And it's hard to remember it now or think about it now, but there was a day when lawyers didn't have computers on their desk. Typical lawyer had a dictaphone who would orally dictate what they wanted to say into a cassette tape that they would then give to their assistant, who would transcribe it into a document, then give it back to the lawyer to review and edit. Once his or her changes were made, they give it back to the secretary for further editing. And that process might occur 3, 4 times. It could take days to get a document done. The partners I had at the firm I'm thinking about were all of the dictaphone variety. They were not real keen on this notion of electronics and computer technology. In fact, they had to be threatened by a client to put in a fax machine because they didn't want to actually have the connection and the expense of a fax. But the client, threatened to pull its work if they didn't get a fax machine. So they put one in. So that's the built-in resistance at the time. With some, when I joined, I asked for permission to drop a telephone line into my office, which was in the way back corner. It was kind of close to the phone cabinet, but not terribly. You had to get somebody to run a physical line over there. This was the days before wireless. So I dropped a phone line in, got a dial-up account. I started communicating with my clients via email. They started sending me work because their companies had just put in network email systems, and my partner saw that I was getting business via email. And so they wanted email too. So pretty soon we had 14 phone lines dropped in. And when we moved to a new space, we put in a network, and then computer technology took off. Okay, so that's an easy example from personal experience about how the computer revolution actually affected the practice of the law. It's an easy one. Harder one for me was some years later when e-discovery was getting born. We had a fairly significant lawsuit that I was handling for the firm, and it was not my client. It was a firm client, and this was one of those hairy cases where it's 150,000 documents not able to be reviewed in person efficiently.
Hmm.
So I started looking around for an e-discovery system, and at that time, the internet wasn't what it is now, nor was broadband. So contacted the company we use for legal research, and they had a legal research product that they said was a very robust e-discovery system that was intuitive and easy to use. And we got the sales pitch on it, and with a number of concerns, we let them put it in. And we started trying to process documents on it to figure out what the other side had produced to us. Well, it turned out that we were oversold the system. It didn't do what it said it was going to do, and it made the job worse. In fact, everybody got frustrated, and I was hearing calls of, I think we should just pull the boxes out and start going through them. We'll just all sit around in a conference room, you know, all 20 of us will knock it out and we'll get it done in a day or two. I heard that more than once. Was that the right call? Well, based on the information we knew at the time, that system would have worked. And ultimately, systems like that work very well. That one did not. And we did, in fact, do some document review. Turns out we didn't need it because for other purposes, the client on business grounds settled it a couple weeks later. So have I had a bad experience with tech? Yeah. Have been good experiences? Yes, obviously.
It's one of those things where you need to experiment and see, like you said, the information you had at the time. You need to be not afraid to fail and experiment and find what works and what doesn't.
Yeah. I would also get a lot of grief from my partners because I was one of those people who would constantly bring new computer systems into the firm. I would try them out on my computer first to see how they worked, see if they were viable, and what the pro and con was, and how they might be integrated. Because I'd had some experience. I don't know if you've ever had this. You go on a trip, you bring your laptop with you, and turns out you need one piece of software that you know exists and you've heard about it. But in order to do the thing you need to do, you need to have that software installed on your laptop. But you didn't think to put it in there because you don't need it once in a blue moon. So you bring your laptop, you go to the thing, you find out you really need it this time for this project. So you download it and put it in. Then you run into troubles with the install. Doesn't work with your equipment. Doesn't work exactly like it says it does. Instruction manual's a little fuzzy about how you get, this file in to do X thing. And you spend hours of frustration and anxiety trying to figure out how to make this key piece of software work. So I have taken the practice that if there's something that's viable, you got to install that stuff before you leave. You need to know how it works. You need to practice on it and experiment with it when you don't have a project in front of you. Because when you do have a project in front of you, you have to know how it works and it has to be efficient. So I'm a strong advocate of early adoption and experience, weeding out what doesn't work to try to find what does. And that will help you be more efficient so that when you roll up to a project or a client's facility or arsenal in your laptop and the information about how to use it is ready to go. That's the only way to work. Clients really hate it when you learn software on their nickel.
And that makes perfect sense as well. And I would like to extend the idea of being proactive to working with clients as well, because just like in your two examples before, the same way how you don't want to have a problem by installing a new piece of software and trying to figure it out when you actually need it urgently, some legal issues could also be avoided if the clients spoke to an attorney beforehand. I know that you publish things like articles as well to engage and educate the clients beforehand. Could you give me one or maybe a couple of other examples of where you start that relationship sooner? So basically you install the right piece of information for a potential firm that might be a client. So when the time to use the legal support comes, it's a smooth sailing from there.
I think it has to start in my practice, it's when they first call. When a potential client first calls and first makes the inquiry, I always have a free initial consultation. I want to know that I can do something for them and that it's within my capability to do so. So I have some clients call up and they talk about needing an extensive, they want to buy a new company and they want to do due diligence discovery. And say, okay, great. What's the company? I said, well, it's a software manufacturer. I don't do software. I could look at the documents every day. I would not know what they're talking about. But I have colleagues who do. And that's one of the things about patent practice. When you're dealing with technology, you have to stay within something that you're competent at and reasonably consistent. And when you see the situation where you will not be competent at it, you need to have a friend group that you can call in and refer the work to so the client gets taken care of and they think well of you in the process, but you don't risk their happiness and productivity by doing something that I'm not capable of doing. And I would prefer not to get crosswise in that situation. So yeah, that's how I approach it. Talk with the client first. See if you're a good fit. See if my skill set is what they need. Then we can move forward.
I think part of that is also being proactive in terms of generating new business, because if the client comes to you and they're not sure what you can and cannot do for them, it's a harder conversation. And like you said, it is important to have somebody you can refer to. What are some of the things you've done outside of getting referrals to start the conversations with companies that knew exactly what you can do for them, and how that maybe transformed your practice, if you want to give a few examples?
Well, one of my practice areas is as an IP lawyer, I help Amazon sellers and brands who sell on Amazon to navigate that particular marketplace. It has a set of rules that are unique. And I work closely with some consultants to sellers and to brands who do other things. I handle the IP side of things generally, patent, trademark, copyright issues associated with that. The folks I work with, they handle things like reinstatements and unsuspensions and interacting with Amazon. And that's a whole particular subset specialty. So, in terms of the niche practice, I got started in that when my wife was a seller and she had certain needs. She was selling a product on Amazon that she received a complaint from a brand that is report that she was selling counterfeit goods. And she looked at me like, what do I do about this? Because I certainly was not. I bought those at Target for resale. And so we tried to work things out, didn't work out, had to file suit in the local district court for defamation. That got their attention. And we finally had a productive conversation. And it turns out that was the first lawsuit in the country where defamation had been attached to filing of an inaccurate report with Amazon.
Mm.
So I don't know if that answers your question, but it's a niche. I happen to know from her experience what that was, and what we did is she took that on to social media and started posting about it, and I did as well. There are certain groups that are directed to sellers on Amazon who face those issues, and so I started there were a lot of questions getting posted, and I tried to answer some of them to the extent that I could about how that works, and that generated a reputation that started generating referral work from those social media postings and word of mouth. Because as more people pulled up, found our case and read what the judge had said, they started to see some value for their situation and their business. And it kind of took off from there.
I think it's such an important lesson for the audience to hear as well, that if you set a new precedent or there is a new piece of technology and nobody knows how to work with it just yet, it's so important to document it and share the experiences, because there's definitely that first mover advantage for a new legal precedent or case to be established, and more potential clients and potentially other firms that would refer work as well will learn by seeing those questions answered, the blog articles written, or the social media posts, and then come and consult on how to approach their situation.
Yes, I agree with that 100%. The advent and possibilities of social media uh, are substantial. I mean, social media has fragmented and segmented into discrete interest groups that if you're marketing your practice, if you are marketing toward an interest group, they self-define what their interest is for you. You just become a member and become active in what they're concerned about. And if you can offer some helpful information or insight, I think that most of those folks are grateful, and they start to see you then as an authority. And when they have an issue, not if, but typically when, they reach out to you first. And in my view, effective marketing means making that first approach welcoming, which means I don't charge for consultations. As I said, it's my first consultation is free. We talk about whether I can do something. And often, it's a 6-minute, 12-minute, 15-minute phone call about whether or not I can help them. if what that help might look like and whether that's something they're interested in. If nothing else, they have information about some possibilities they didn't think of before.
One of the ways I think that works, and it has worked really well for you, is because you have a niche. You have a clear understanding, like you gave with the software example, of what you do and what you don't do. What would be your recommendation to attorneys that go into an area of law and they try to be generalist in that area of law, especially when it comes to generating new business?
I faced this issue with in my prior firms when we were trying to develop. I was sitting down with another partner, and we were in my office trying to come up with ideas to develop a greater client base. And the number one question we always had was, why do clients want to hire us? Why would they want to come see us? So did we tell them that we're great lawyers? Well, you really can't do that because everybody's presumably a great lawyer. That's kind of the starting point. You tell them that our fee rates are better than everybody else. Well, that tells you it's a price competition then, and it's a race to the bottom, not really where you want to be. So how do you convey expertise without merely stating it? After reading a number of books and some experience, it became pretty clear that publicizing a niche practice that others considered to be difficult is the way to demonstrate expertise without saying you have expertise. For example, back in the day, the patent office had something called ex parte reexamination. They still do. I had a client at that time who was concerned about a patent that was going to impinge on his business. And he said, how can I do something about this without getting involved in a very expensive lawsuit? And I happened to see that I remembered the commissioner's notification that the ex parte reexam process was now available. And so I told the client about this process. And it's a process to put together your information and send it into the patent office and say, look, we have some concerns about the validity of this patent and its claims. And here's why. That's a document formally called the request. And you pay a fee, and the patent office looks at it and they determine whether it raises a substantial new question of patentability as the test. So we did that, and the examiner did. And so they re-examined it and they found that it raised new questions, and the owner apparently thought so too, because they abandoned the claim. So it turns out that was the first ex parte reexamination request in the country, 95/0001. And once that decision came down that about the patent, I wrote an article about it, posted it up on our firm's website. At that time, social media hadn't really taken off yet. But about 4 months later, I got a call from somebody I had never heard of before. And he said, are you Lance Johnson? I said, yeah. He said, did you write an article on ex parte reexamination? I said, yes, as a matter of fact, I did. And he said, well, I have a problem that may or may not involve that, but it sounds to me like you could probably help me. Can we talk? So I did. He became a client. Turns out he didn't need a reexamination, but he did have needs for 5 patent applications and some business consulting. So it kind of took off after that. So the take home lesson for me was, if you have a niche practice, advertise it, because clients will think that if you can do something that complicated, certainly you could do something easier that is the problem you're facing now. And so they'll have trust that you can do that. So advertising, yes, you got to find a way to get the word out in a way that demonstrates expertise without merely stating that you have expertise. You have to show it.
I think that's such a wonderful lesson that I hope more firms will take to heart. That demonstrating exactly how they solve the very complicated cases or the first cases of a kind, definitely give that assurance that, well, if they did that, then something more routine will be no problem at all. And that's a great point of differentiation. One of the things that you mentioned you use to advertise as well is Google Ads. Do you want to talk a little bit about how you decided to start that experiment and whether you found that productive and profitable for your practice?
Absolutely. I've been active, have been active for a long time in the American Bar Association's Law Practice Management Division. And I was active on the editorial board for the Law Practice magazine. And as part of that, we would find authors to write the articles for the 6 issues a year that we published. One of the articles I wanted to write that I couldn't find anybody to write on was the value of online advertising to a law practice. And everybody said, advertising is always a return on investment. You can never quantify that. It's a fuzzy thing. You just have to pick your number, invest it, and just presume that it's going to work. Something about that bothered me. So I launched a personal test program over the summer. It was a 3-month experience. I contacted a company to establish a web-based advertising program for my firm and my practice. I was going to invest $1,200 a month for 3 months. And what they did is they set up a separate website and a phone number that would reroute to my phone number, but it's something that they could track. And what I did is I ran that for 3 months. When the calls started coming in for work, I started tracking the clients where they got my number, how they got it, where they saw me. I started tracking the work that I got to those ads. And I found that I was getting about 187% rate of return on that investment ad dollar. So I wrote an article on that. We published it in Law Practice Magazine. And my subsequent experience with advertising has been that that's pretty consistently about the right number. So you get almost twice what you invest to get your name out. As you get to be more known, the value of that name and the name recognition and referral takes off. That is web-based advertising is something that senior partners really hate. But when you have your own firm or you're a younger partner and if you can afford it, I strongly recommend it because it pays off. Because those clients, I was only tracking the initial work that I got from the ad. Those clients stuck around. They came in with second, third, fourth, fifth projects. So that real rate of return was significantly higher than 187%. I can't tell you what the number is, but I know it's higher. So it's a worthwhile exercise. And the tools to track ROI on web advertising are there now. And so I encourage everybody who's got a practice and wants to develop a greater one, make the investment. You can do it from a fairly nominal sum, $100, $200 a month. Pick your company, pick your platform, figure out how you want to do it, and you can go from there.
When you described that experience, one of the starting point was getting this data, and we find that to be completely true as well. We have to know the numbers of what the case is worth, what the company would be interested in spending on advertisement. What are some of the other things that a law practice should look in the marketing partner to make sure from the get-go that everybody's expectations are aligned and it could be a net profitable experience for them?
Pardon me. I think aligning expectations is always an issue of conversation. You have to talk about it. You have to have a realistic appraisal of what you're willing to do, what you can do, what's within your, wheelhouse to want to follow up. Because anything that involves advertising consistency, you have to follow up. You can't just send the message out once and expect it's going to be received. From what I understand, the general expectation is that a potential client needs to hear your message at least 3 times before they believe it and will act on it. So you need to be thinking in threes at least, preferably something long term, something continuous that you are willing to stand behind and support.
Lance, what is the one maybe marketing experiment that you wish to do in 2026 when it comes to growing either as a solo practitioner or something that you wish other law firms did out of curiosity to see how that can help them acquire new great clients?
I think there's a lot to be said in the market of people that I service. Now, I'm a solo practitioner. I work with individuals, small companies, maybe up to medium-sized companies on occasion. All of them are looking for ways to cut the ad spend or the cost of legal services. They're trying to find ways to leverage the use of artificial intelligence and those tools to make their business better, faster, cheaper, et cetera, get better information. They expect their lawyers to do that. I think the days when a lawyer can merely throw more time at it for a complex project, those are going to start to be tempered by an expectation that there are automated ways to do that. So in terms of Marketing, I'm thinking right now that 2026 and 2027 might be the start of time for a project in this web facing that allows clients to interact with some of my standard forms in a way that they can use those forms to generate for themselves the sort of content and basic information. And I'm thinking here like a non-disclosure or confidentiality agreement. Those terms are very standard across the industry for a very simple agreement.
Mhm.
And if the client wants to use that form, are there malpractice issues? Potentially. Do those have to be clients in order to do that? Yes. Should the lawyer look at the document before it goes to the client and gets blessed? Yeah, probably. So there are ways to do that, but I think clients are going to demand that sort of responsiveness from their counsel because at some levels, some legal services are going to be seen as commodity level, easy services that they don't want to pay a lot of money for. They don't mind buying a form that they can use 300 times. But that's really forms are problematic in that clients think that it's a one size fits all when in fact a lot of legal agreements are anything but.
Mm.
So somebody needs to look at it, you need to make some questions. And I'm still playing around with how does it make sense to try to automate or do that, and if in the process then help my clients and promote my firm, that we can provide a tool that helps the client get what they want done cost effectively, timelessly, 24 hours a day. If I have a client who is in, let's say they're in England, and they need an agreement at what would be 2 a.m. in the morning my time because they want to have a quick conversation, I'd love to have a tool available that they could go on my website, fill out an AI based form, have it spit out my standard confidentiality agreement, and email it to them as a document that they could then sign and they could get on with their business without having to necessarily involve me, but in a time frame that is convenient for them. That's my thinking right now. That may change, but it's something that comes to mind that I've been kind of pondering in the background.
Level of personalization. And I think the tools are there. Is just a matter of firms actually putting it into the practice and see how it goes and working out, like you said, insurance versus malpractice and things like that, that they're actually useful in the greater scheme. Lance, where can potential clients find you online if they're interested in your work?
My website is ljjlegal.com. My phone number is there. I advertise on Google Ads. So if you search Lance Johnson, patent attorney, I will probably pop up.
Sounds great. Lance, it's been a pleasure having you on the Growth Switch today. Thank you so much for coming.
Thank you, Alex.
Pleasure.